I heard that.
All right. I'm responding to the claim that modern intellectual property law stifles technological innovation. Now, when doing research for this, it was really hard to find any research that didn't counter this claim. But what I did find said, according to my speaker's first claim, which was intellectual property laws inhibit the development of new ideas, that a quote by a philosopher by the name of George Hegel, he stated that means of advancing the sciences and art is to guarantee scientists and artists against theft and to enable them to benefit from protection of their property, just as it was the primary and most important means of advancing trade and industry to guarantee it against highway robbery. So they put patents in place to protect people's ideas and such, so that they could further advance the sciences. And he also stated that laws have not been adapted to address new forms of media. The patent laws and such are very old, and a lot of people didn't rival against that because they are old. And media is a rapidly growing thing, and it takes... The second claim is that intellectual property laws reward companies, not inventors. Inventors, he stated that it was really expensive to purchase a patent to protect their ideas and such, but inventors should know what they're getting into. It's going to be expensive, and hopefully your invention will in the long run pay itself out so that you don't have to worry about those patent fees. As the United States Patent and Trademark Office stated, fees vary depending on the type of patent application you submit. Fees may also vary according to the way you claim your invention. So inventors should go into that knowing what they're getting into, basically. He also stated that litigation in the event of a patent dispute is costly. And no one's going to argue that going to court is not costly. But what was stated was that by the Due Process Institute, that due process levels the playing field when it comes to litigation. So he had stated that they go to court through litigation because they rival on who really owns the ideas or the laws and such. And so with due process, it gives them an equal playing field, I guess you could say in that. His third secondary claim was that intellectual property laws are too easily exploited. The statements were kind of vague that he mentioned in this, saying that the patents cover a broad range of topics and the laws are articulated onto technologies and concepts that they were never intended to. But what I collected was that a lot of the laws, you don't really know what they're intended to do until you actually find out. Because a lot of patents and stuff, a lot of them are newer that they have problems with, and technology advances so fast that you're not really sure what outcomes can be like nowadays. And as stated by professors concerning who owns, or hold on. He also stated that laws are frequently abused to sue companies on weak premises. Through research, I found out that that's kind of an old statement, and it was found out by professors at Columbia Law School that it's now harder to prosecute patents because they're becoming more complex. So a lot of the new technologies they're coming up with are very complex, and it's really hard to prosecute against them in court. And so in conclusion, even though I didn't find much research, I did find that intellectual property laws, there are some good sides to them that can outweigh the bad sides, especially with new technologies. Thank you.
All right, well, you state the advocate's main point on the individual points. You're signposting pretty well as you go along. I think you've got a good generic argument at the beginning to kind of explain what the whole value of this is, and I think that puts it on a reasonable premise. But that's that's a long-term concept. It's almost biblical in nature, one of those commandments about how property rights and intellectual property ought to be treated. That's okay. Then you kind of concede this notion that the laws are not adequate. I don't know how true that is. I mean, I haven't done a lot of research on this, but I suspect that there have been modifications of the laws, especially in the last 20 years, that deal with intellectual property rights, with digital technology. They may not be as complete and clear as the advocate thinks that they ought to be, but I think you need to dig a little bit, because I'm sure that there have been revisions passed to address a lot of those issues. And it may, in fact, be that those revisions are the source of the problem that the advocate's talking about, but at least you wouldn't be arguing, well, we're just applying laws from 1898 to 21st century technology. The general argument on the second point concerning it being companies and not individual inventors, you mostly say it just comes down to cost issues. I think you've got a good argument when you say, look, when it comes to fees that they have to pay, it varies depending upon the nature of the patent that they're seeking and how broad they want that patent to be. That sounds to me like it would adequately protect somebody who has a specialized idea that their costs would not be particularly large, and I think that's the way you need to frame that one. On the litigation argument, you basically say due process provides an equal playing field. I think that's fair. By the way, if somebody believes that their patent rights have been violated, getting a lawyer who's willing to support them on that simply means that you grant them contingency fees, and you don't have to pay up front. They pay only if they win in those circumstances. So there are legal ways in which people can protect themselves without necessarily having a bucket load of money, because especially if the offense is egregious and they've got a valid claim there, a lawyer would be able to see that and say, look, there's a rainbow at the end of this argument, or there's a pot of gold at the end of this rainbow, I should say. A rainbow at the end of the argument, that would be kind of weird. I'm kind of tired, sorry. I'm not sure why there would be any difficulty for somebody finding somebody to defend their rights in that situation. And, then I think that the last point basically just argues, that there's some vague issues about this. It starts to sound a little bit circular. The quote that you have from the Columbia Law Review, I think, is okay, although it may, it may apply the other direction too, because it's kind of ambiguous in its application. But the argument's well organized. I like that. I do think you need to look at the advocate's evidence a little bit more for contrasting points. All right, thank you all for your patience. Apparently we're going to